If you care about the future of birthright citizenship in the United States, mark your calendars for April 1st, 2026. That's when the U.S. Supreme Court is going to hear oral arguments for and against Trump versus Barbara. Trump versus Barbara is a class action lawsuit filed against the executive order 14160. If you remember, on I think it was his very first day in office, Trump signed an executive order limiting birthright citizenship, which a lot of people consider unconstitutional because it violates the 14th Amendment. So now, if you'll remember, they did reach a decision, the Supreme Court reached a decision about this case, but it didn't go to the main merits of it. It didn't go to the real question. So we're going to look at what was decided before and what's going to happen on April 1st. I wish it was a joke. I thought, couldn't they have picked April 2nd or something? But anyway, it's April 1st. So let's look at the facts of the case, right? January 20th, 2025, Trump signs this executive order number 14160. That's titled Protecting the Meaning and Value of American Citizenship. And that declared that people who were born in the United States are not United States citizens at birth if their parents lack sufficient legal status. Specifically, that means if the father's not a U.S. citizen or a permanent resident, and the mother is not here in legal status, then that child, her child, would not gain U.S. citizenship at the time of birth. There's two of them. That's one of them. One is if the mom doesn't have legal status here and the father's not a U.S. citizen or permanent resident, their child is not going to be a U.S. citizen at the time of birth, even if they're born here. The second category is the same thing where the father's not a U.S. citizen or permanent resident, but the mother is only here. She might be here legally, but she's only here on a temporary visa, such as a visitor's visa or a student visa. So this executive order was issued on the alleged basis that the 14th Amendment Citizenship Clause doesn't confer birthright citizenship on such children because they are not subject to the jurisdiction of the United States in the constitutional sense. So let's take a real quick, brief look of this 14th Amendment. I'm only going to do Section 1. It's a pretty long amendment. As you probably know, I think it was ratified in 1868. It's one of the Reconstruction amendments, and it was meant to give citizenship to the freed slaves, which is another one of Trump's arguments, that this isn't meant for every Tom, Dick, and Harry. It was just meant for that specific thing. Of course, since 1868, it has been considered the reason why anyone born in the United States is a U.S. citizen. So let's take a quick look at this 14th Amendment, Section 1. This is what it says. All persons born or naturalized in the United States and subject to the jurisdiction thereof, that's very important, that phrase, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of laws. You will often hear, if you follow any kind of legal cases, that equal protection clause. The Constitution has an equal protection clause. They're talking about the 14th Amendment, that particular line right there, that citizens of the United States um, that particular line right there. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So, who the heck is Barbara? Well, there were three families that challenged this order on behalf of themselves and other people similarly situated. That's one of the reasons we consider it a class action suit. It's not just for them, it's for them and anyone like them. One class representative is Barbara. Again, these are pseudonyms. They're not their real names. But the woman they call Barbara is a Honduran asylum applicant whose child was due in October of 2025. Another is Susan, a Taiwanese citizen in the country on a student visa at the time of the suit. Her daughter was due in April of 2025. And who is that? Susan. Susan's child's passport application was in progress when the son was born in March of 2025 and initially received a U.S. passport. These families filed suit, as I mentioned, under pseudonyms, alleging that the executive order unlawfully strips their children of citizenship guaranteed by the 14th Amendment. They seek to preserve access to citizenship-related benefits such as Social Security, SNAP, Medicaid, passports. Now, what happened? So, of course, as soon as this comes down, the lawyers get jumping and they start filing these lawsuits. A U.S. District Court in New Hampshire issued a preliminary injunction. And remember I mentioned that there was something that was determined about this case earlier by the Supreme Court? That's what this was. The injunction also, first of all, the preliminary injunction went out to everyone in the country. And it certified a nationwide class of children affected by the order. And the court held that the plaintiffs were likely to succeed on the merits of their constitutional and statutory claims, which if you ask any attorney before we started talking about this, they would have said, this executive order doesn't have a chance in hell. But you never know. You never know with the Supreme Court, although they did just knock down all his tariffs. So that's positive. But we're going to talk about that. In fact, I'm going to have another, probably it'll come out in mid to late March. I'm going to do another video on the justices themselves and how most people think they're going to vote on this. Spoiler alert, most people think that the justices are going to knock down this executive order as being unconstitutional. We can keep our fingers crossed. You never know. It's not over till it's over, right? So, what happened? District Court of New Hampshire issues a preliminary order, right, and certifies a nationwide class. The decision is appealed to the First Circuit Court of Appeals, which would handle New Hampshire. But before they even get to make a ruling on the case, the Supreme Court stepped in, granted certiorari, basically says, we're going to take this case. We're going to listen to the arguments. We want to decide this case. So there wasn't any decision from the Circuit Court of Appeals. But this case isn't just about immigration law, right? It's about who gets to define the Constitution. Is it the Congress? Is it the President? Is it the Supreme Court? Well, a little civics class. In fact, if you had gone over any of my "Are you smarter than an immigrant?" questions, you should know that what does the Congress do? They create the laws. What does the executive branch do? They enforce the law. And then what does the Supreme Court do? Well, the judiciary interprets the laws. They determine what's constitutional, what's not constitutional, which is exactly where we're at. There's going to be a lot of similarities between this and the tariff case. Well, when I'm filming this, I'm filming it on Saturday, the 21st of February. They've just come, the Supreme Court's just come out with this law kind of striking down all of his tariffs. And then what does he do? The same day, he puts another 10% tariff on everybody worldwide. So, I don't know. It's very interesting. One of the arguments he's going to have, I'm sure, is that, hey, it's quite clear in the Constitution, in the second article, that the executive branch is in charge of immigration. That's also one of the reasons, by the way, that's one of the reasons why some of these states, like Minnesota, Michigan, Pennsylvania does this, different state or local police, they don't want to necessarily help the feds with immigration law because that's not their purview. Only the federal government, the executive branch, which would be DHS, which includes CBP and ICE, only they are supposed to be doing immigration law, not the little state police forces or the county police forces, just the federal ones. So, I mean, it's pretty clear that ever since, what was that case? Marbury versus Madison? Oh my God. I'll put it in. If it's not Marbury versus Madison, which was the first case that was ever really decided, where the Supreme Court came out and said, you know what, we've decided that we're in charge of deciding whether or not a law is constitutional. But if that's not the right name, number one, I'm going to be totally mortified. And I'll also put the correct name down on the screen. I'm pretty sure it's Marbury versus Madison. Really, I think it's one of the very first cases that you ever read about in law school. So that would take me going back to 1988. So forgive me if I've screwed up my M's. But anyway, so you should know, basically, there's two ways to change the Constitution, right? Now, one of the things you need to keep in mind is, let's say the president wants to change that 14th Amendment. He doesn't like the way it sounds. And he wants to basically do what he's doing here, which is just say that all the other presidents and all the other Congresses have gotten this law wrong. All the other courts, they've all gotten this wrong. And I'm here to say that this is the correct interpretation of the 14th Amendment. Well, you can't just repeal an amendment. You'd basically have to do a new amendment. Best example of that is prohibition. What was that, 1919? Hold on, I gotta find it because I wrote it all down. Yeah. The prohibition, this is an easy mnemonic device if you give a darn about what amendment is for what. The 18th Amendment is when they prohibited the sale and manufacture and transportation of intoxicating liquors, ratified in 1919. And I always remembered that it was the 18th Amendment because it's that 18th Amendment is then later repealed by the 21st Amendment. And that's so easy to remember. 18, 21. We've gone back and forth, at least Pennsylvania has, as to how old young people are allowed to be to drink. So it's easy. It's 18 and the 21st repeals it. And I also can help you with the amendment where the women got the right to vote. And that's the 19th Amendment. So I've always had, since law school, I've had this mnemonic device. 18 is prohibition. 19, once the guys sobered up and they're like, oh, geez, we never gave women the vote, they issued they issued the right for women to vote. And then eventually, back in the 1930s, they said, oh, you know what? Let's forget about this whole not drinking thing. So, and remember I mentioned something about the Supreme Court had touched on something about this case before, but that's procedural stuff. What the Supreme Court didn't like in this case was that one district court in New Hampshire could do an injunction that was nationwide, and they didn't like that. So they took up that issue last year, 2025, and they basically ruled that that's not happening anymore. So now they've gotten to the meat of this particular case. And the issue that the Supreme Court's going to be deciding is, and they always make, this is a legal thing, you know, the issue is, they try to make the issue as specific as possible, not that it can get all extrapolated out and have all kinds of different things or different interpretations. Not that it can get extrapolated out and have lots of different interpretations. So the issue in this case on April 1st is going to be, is a presidential executive order that denies U.S. birthright citizenship to children born in the United States because their parents are unlawfully present or in the country on temporary visas consistent with the Citizenship Clause of the 14th Amendment. So why did the Supreme Court decide to take this case up, particularly before the appeals court had a chance to make a decision? Well, lower courts blocked it almost immediately, and because the case raises three, in my humble opinion, massive constitutional questions. One, what does subject to the jurisdiction really mean? Okay? Like diplomats who live here, and generally their spouses and children are not subject to the jurisdiction of the United States. But how about somebody who's here illegally? They weren't born here. Are they subject to the jurisdiction of the United States? For me, that's a no-brainer. Of course they are. They can't say, hey, look, you can't arrest me. I'm from Salvador. You're not allowed to arrest me. You have no jurisdiction over me. So that's supposedly one of the main arguments that they want to hear about, that they're going to make decisions about. What does subject to the jurisdiction really mean? Number two, can a president change citizenship rules without Congress? Right? We just went through that, although I might have erased it. But we all know that the legislature, Congress, they make the laws, the executive branch enforces the laws, and the courts interpret the laws, right? Well, how can a president change citizenship rules without Congress? You're making up a new law, basically. I'm sure they're going to argue that, wait a minute, we're in charge of immigration. We can do whatever we want as far as the regulations go. And number three, the third big question is, should the court overturn or narrow long-standing precedent? Which I'm going to talk in about 5 minutes about what that long-standing precedent is. You know, this isn't based just on the 14th Amendment. This has been interpreted by the U.S. Supreme Court in a very, very famous case, which we're going to talk about in a second. So who's going to argue what, right? Trump's side is going to argue that the 14th Amendment has been misinterpreted, for sure. Citizenship should require more than just birthplace. The executive branch has authority over immigration, enforcement, and definitions, which they sort of kind of do. It'll be very interesting to see how this particular Supreme Court decides this case. We won't hear that until June. But on the other side are the challengers. Well, who are the challengers? You've got the individuals that I mentioned earlier, and all the people who are members of those of the classes. You've got a lot of the states. You've got advocacy groups that are going to be sending amicus briefs. The challengers are going to say that the Constitution is clear. The president cannot rewrite constitutional meaning through executive order. And citizenship is constitutional. It is part of an amendment, which is part of the Constitution. It's not discretionary. And presidents don't get to redefine amendments. That's going to be another argument. And this probably for me is the most important one. Changing this would destabilize millions of lives instantly. You know, imagine you have two women giving birth in a hospital, one in room A and one in room B, and one woman's kid is a U.S. citizen and the other one's not. Then you're going to have the same situation that you have in France. And, you know, because France, if you're born there, doesn't make you necessarily a French citizen. Germany's the same way, doesn't make you a German citizen. But now you have two tiers. You know, what the heck are they if they're not citizens? What are they? You can't deport them because they never entered illegally. Are they here illegally? I mean, it just throws everything into total chaos, in my humble opinion. I'll be very curious. Believe me, April 1st, I will be watching this. I hope that they televise it. I don't think they normally do they? Do they normally televise oral arguments with the Supreme Court? I don't think so. But believe me, CNN and MSNBC and Fox and every political pundit on YouTube will be talking about it and telling you what you should think. So remember I said that there was a very old precedent that has been the law of the land for a gazillion years, right? Well, that precedent, that case is United States versus Wong Kim Ark. Wong Kim Ark held that a child born in the United States of parents of Chinese descent, who at the time of his birth are subjects to the Emperor of China, there you go, or they're subjects of the Emperor of China, so are they subject to this jurisdiction thereof of the United States? Who at the time of his birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States, and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, automatically became a U.S. citizen at birth. Wong Kim Ark was the first Supreme Court case to decide on the status of children born in the United States to alien parents. And by alien, I mean someone who's not a citizen of the United States. I'm sorry, I'm an immigration attorney, have been for decades, and I refer to aliens all the time. It's not meant to be disrespectful. It's a term of art, and if they're not a citizen, then they're an alien. I know, I'm sorry. It's a hard habit to break. But, so Wong Kim Ark was the first Supreme Court case to decide on the status of children born in the U.S. to parents who aren't U.S. citizens. This decision established an important precedent in its interpretation of the Citizenship Clause of the 14th Amendment, which is, like I said, something they're going to be talking about. That's is this mother subject to the jurisdiction of the United States? So, 2 seconds just to look at this. Wong Kim Ark was born in San Francisco, had been denied re-entry to the United States. He took a trip abroad, and then he was denied re-entry into the States under the Chinese Exclusion Act. It held that the Citizenship Clause should be interpreted, quote, in light of the common law, unquote. That's a topic for a whole different video. What the heck is the common law? I'm going to write that down. I'm going to do one on that. The Supreme Court's majority concluded that this phrase referred to being required to obey U.S. law, which is what I just mentioned, right? You can't say to a cop, you're not allowed to arrest me. I'm not born here. You have no jurisdiction over me. The court held that being born to alien parents was not one of those exceptions. The court's dissenters argued that being subject to the jurisdiction of the United States meant not being subject to any foreign power, which is what Trump is going to say, any foreign power. That is, not being claimed as a citizen by another country via jus sanguinis. I'm going to say that wrong. That's based on blood, right? I mean, basically, where you're born, you can become a citizen by birth in two ways. One, in the United States, as of right now. If you're born here, you're a citizen. Or, let's say you have a U.S. citizen mother who's traveling, and she's in Mexico, visiting friends or whatever. And oops, unexpectedly, she gives birth in Mexico. Unexpectedly, she gives birth in Mexico. Well, guess what? That child is still a U.S. citizen, even though they were born in Mexico. I think they also have dual citizenship, and you might be able to get Mexican citizenship too. But let's say she's in, just to make it easy, she's in Paris, or she's in Germany, or she's wherever, and she gives birth. Well, that child, even though not born in the United States, is born to a U.S. citizen mother, so that child is by blood a U.S. citizen. I think everybody knows this, don't they? I don't mean to be being so basic about it. Let me know in the comments if you think, speed it up a little bit, because this is obvious. Everybody knows this, but I don't think everybody does. My friends who are lawyers are very interested in this, because most of my friends who are lawyers are also immigration attorneys. But most of my friends who aren't lawyers, I start talking law to them and their eyes just glaze over. The court's dissenters, however, argued that being subject to the jurisdiction of the United States meant not being subject to any foreign power. Meaning, if you could get citizenship through the nationality of your parents, which is called jus. I'm butchering this, I'm sorry, but it's jus sanguinis. So one is through blood and one is through birthplace, right? So if you have someone who's from Costa Rica born here, if their parents were both Costa Ricans, then the dissenters argued that they are subject to the jurisdiction of Costa Rica. The child is also subject to the jurisdiction of Costa Rica, and thus is not subject to the jurisdiction of the United States. So you're going to hear a lot about this particular case, Wong Kim Ark. To be honest, the Supreme Court really hasn't looked at this particular subject since Wong Kim Ark, which was 1898 that came out. So that's probably why, it's probably one of the big reasons why they decided it's time to take a look at this. Even though the Supreme Court hasn't ruled on anything more since Wong Kim Ark, the lower courts have all accepted this as dogma. And dogma just means it's an established tenet. It's like understood that somebody born here is subject to the jurisdiction of the United States and is a citizen by birthplace. So anyway, I'm going to be really paying a lot of attention to this. It's about the 1990s, which is, I guess, about the time the expression illegal alien comes into being. They start using that a lot. But really, since the 1990s, there's been a lot of controversy about this long-standing practice of granting citizenship to people born in this country. And there have been some attempts from time to time in Congress to restrict birthright citizenship, either through statutory redefinition or by overriding both the Wong Kim arc. Look, this is what happens. You have the Supreme Court comes down with a decision like Wong Kim arc that basically says if they're born here, with a few limited exceptions, if they're born here, then they're U.S. citizens. Then, if you don't like that, then Congress is capable of making a new law that will override the Supreme Court decision. They could do that here, too. They could do that here. But I don't think this Congress is going to have the time to do that. Because like I said, they're going to hear oral arguments April 1st, and we probably won't get a decision until June, probably late June on this. And so if the Congress, which right now is held by the Republicans, if they want to create a law that's going to change this, they've got a limited period of time to do that.